Good evening. The date is Monday, October 6th. The time is 6:10. And we are located at our CPC offices on 3631 Perkins Avenue, 4th floor. And we are calling case 2025-CPC-002 for an evidentiary hearing before the full commission. And we'll start with the roll call. Commissioner Truro.
Present.
Commissioner Coleman.
Present.
Commissioner Kincaid.
Present.
Commissioner Mason.
Present.
Commissioner Miller.
Present.
Commissioner Morel Bonito.
Present.
Commissioner Nelson.
Present.
Commissioner Rodriguez is not present. Commissioner Umison.
Present.
Commissioner Van Leer.
Present.
Commissioner Zayed.
Present.
And I am present as well. All right. I'll turn the meeting over to my co-chair, Sharina Zayed, for the reading of the meeting decorum.
This meeting of the Cleveland Community Police Commission is a lawful meeting. Under section 605.04 of the codified ordinance, no person with the purpose to prevent or disrupt a lawful meeting shall do any act which obstructs or interferes with the due conduct of such meeting. Members of the public are invited to speak in accordance with the public meeting rules. Disruptions, including but not limited to speaking out of turn and or making loud utterances that interferes with the due conduct of this lawful meeting, may constitute as a misdemeanor in violation of section 605.04. If this meeting is disrupted, I will call out for a recess and the room will be cleared. Persons who violate the city ordinance and commit misdemeanors may be subject to prosecution. When this body is able to return from recess, then in compliance with the Ohio Open Meetings Act in sections 101.021 of the codified ordinance, the meeting will be open to the public. I'm also going to read the CPC Statement of Neutrality. The Cleveland Community Police Commission is a neutral party in this hearing. Our role is to simply hear the record evidence in the case along with any additional testimony or evidence as may be submitted and decided if the discipline administered by the Public Safety Director, Dornett Drummond, is in alignment with the Cleveland Department of Police Corrective Action Policy, also referred to as the discipline matrix. This hearing is not a retrying, reweighing, or reinvestigation of this case. The CPC's task is to determine if the discipline that was administered based on the internal affairs investigation is inconsistent with what is required in the corrective action policy. The standard of proof that the commission shall use in guiding its decision making is a preponderance of evidence. The commission may modify the disciplinary determination if the preponderance of the evidence in the matter shows that the original discipline or the lack therefore was misapplied pursuant to the discipline matrix at the time of the incident. Preponderance of evidence means the greater weight of evidence. For example, based on all of the evidence, it is more likely than not that original discipline imposed or lack therefore was or was not misapplied.
Thank you. Next, we will hear from our Executive Director, Alex Nordine, who will present a brief summary of the case.
Good evening, co-chairs, commissioners. The commission is convened here today to review the disciplinary case matter 2025 CPC 002, with the underlying case being CPD 2023-012 involving Officer Kilbane. The purpose of the proceeding today, as expressed by the co-chairs, is to determine whether the discipline imposed by the Director of the Department of Public Safety is consistent with the CDP's, the Cleveland Division of Police, disciplinary matrix, also known as the corrective action policy. Now, this case originates from an IA investigation based upon Medina, the City of Medina Police Department notifying the CDP of a report made against Officer Kilbane. Internal Affairs conducted the requisite investigation into the matter via 3 levels of review. IA, Internal Investigations, preferred two specifications for pre-disciplinary hearing. Those two specifications are based upon alleged violations of the CDP Manual of Rules 2.01. CDP Manual of Rules 2.01 provides in relevant part, personnel shall not violate any law of the United States, the state of Ohio, charter provision, or ordinance of the city of Cleveland, nor shall they engage in any conduct that would constitute a crime under the laws of the United States, the state of Ohio, charter provisions, and the codified ordinances of the city of Cleveland. The specifications under review by this commission are two. First, that Officer Kilbane did violate Manual of Rules 2.01 by allegedly misleading the City of Medina Police Department while conducting an investigation into a report made against him. And two, that Officer Kilbane did violate Manual of Rules 2.01 as a result of his being found by the Domestic Relations Division of Medina County to have engaged in a pattern of conduct from September 2023 to November 2023, satisfying the elements of menacing by stalking. The discipline imposed or not imposed in connection with those two specifications are now under review by this commission.
Thank you. Now we will move on to hearing opening statements. Each party may present a brief opening of no longer than 10 minutes outlining their case. Since there is no complaint in this case, we will start with the respondent officer. Officer Kilbane or his representative may now present an opening statement. So we don't have any representation from Officer Kilbane. So do we have any representation for Officer Kilbane? None? Okay. Okay, so up next is the presentation of evidence. The executive director, complaining, and officer in that order may present evidence and witnesses. All right, so I'll read some of the guidelines. Each presentation shall be no more than 20 minutes total, including all remarks by the presenter and all direct witness statements. Cross-examination of witnesses, questions by commissioners shall not count against this time. No more than 3 witnesses may be called during a given presentation, who will be allowed to speak up to 5 minutes. After each presentation or witness statement, parties may cross-examine that speaker. After each cross-examination by the parties, a roll call will be called to identify commissioners who would like to ask questions of that given presenter or witness. All commissioners' questions shall go through the chairs. This process will repeat until a given presentation, including all direct witness statements, have concluded or reached a maximum of 20 minutes. Since there is no third-party complaint in this matter, a presentation will be made by the executive director and respondent officer if he desires. Interim Executive Director Nordine, do you have any additional evidence to present or witnesses to be called by the commission?
To the co-chairs, yes, on behalf of the commission directive, Director Drummond is present today.
So each party may cross-examine witnesses called by the other party. Parties may choose to call not more than 3 witnesses who will be allowed to speak for up to 5 minutes. In this segment, all parties should speak through the chairs. After commissioners have asked their questions, another roll call will be done to identify any other potential questions. Questions for the parties or cross-examination of witnesses is permitted by all commissioners. So at this moment, we will call Public Safety Director Drummond as a witness.
You already did.
No, he did. He said it was in there.
So there's no.
There's no questions.
Executive Director Nordine, do you have any additional evidence?
Thank you. The prior statement was just a sort of summary, a preview of the actual case package before this commission. As I mentioned, this case originates from an IA investigation as a result of alleged misconduct by Officer Kilbane. On October 30th, 2023, the Medina County Police Department notified the CDP about a police report filed against Officer Kilbane while he was off duty. The facts in this presentation are based upon the record evidence before this commission, the reports before this commission, and the underlying investigation by IA, along with the ED's independent analysis of the records. As I mentioned in my summary, there's two specifications under review. I'll take the first specification initially, and then the second specification for ease. Specification number 1 surrounds an incident between a third-party petitioner and Officer Kilbane. The petitioner in the alleged incident underlying the matter alleged that Officer Kilbane placed a tracking device in her vehicle and that he approached her vehicle in a parking lot while parked in the vehicle and said something to her and then fled off. Now, the petitioner filed a police report with the Medina Police Department. The Medina Police Department, as part of their investigation, contacted Officer Kilbane, a CDP police officer. Officer Kilbane denied being within the city limits of Medina during the incident. Officer Kilbane further denied placing any tracking device or audio device in the petitioner's vehicle. Upon independent investigation by the Medina Police Department, the Medina Police Department found via the flock safety system that the license plate that was associated with Officer Kilbane's car was in fact located within the city limits of Medina around the time of that specific incident. Now, IA, as I mentioned in my summary, conducted an interview of the matter. During IA's investigation, IA conducted what's called a Garrity interview. Under penalty of termination and discipline, IA interviewed Officer Kilbane. Officer Kilbane, during that interview, admitted that he told Medina that he was not at the location during the incident. Officer Kilbane also admitted to placing the recording inside the vehicle of the petitioner. Based upon this misconduct, IA concluded that by the preponderance of the evidence, there was sufficient belief to support a finding that Officer Kilbane violated Manual Rules 2.01. Specifically, the preferring of charges was that Officer Kilbane did mislead the Medina Police Department during the investigation into the petitioner's police report. IA found that in addition to Kilbane's own admission, traffic camera footage supported that conclusion. As a result, IA concluded that under Manual Rules 2.01, this conduct could constitute a crime of obstructing official business in violation of Ohio Revised Code 2921.31, providing that no person without privilege to do so and with the purpose to prevent, obstruct, or delay the performance by a public official shall do any act that hampers or impedes a public official in the performance of that public official's lawful duties. Now, importantly, the IA investigation went through 3 levels of review. 1, the sergeant, 2, the lieutenant officer in charge, and 3, the superintendent. Each individual person within IA found that the matter should be sustained. Subsequently, Officer Kilbane received notice of that charge. He was charged with Group 3 level violation pursuant to the corrective action policy or disciplinary matrix. Officer Kilbane did attend the disciplinary hearing, which afforded him his due process right to be heard. And then upon conclusion of that, the Chief Safety Director, Drummond, issued a disposition letter. The disposition letter relative to this specification was twofold. 1, Director Drummond did find that the veracity of the allegations supported the evidence. In other words, he found that the allegations as determined by IA were substantiated. In fact, Director Drummond expressly determined, quote, that Patrol Officer Todd Kilbane, number 2234, did mislead the Medina Police during their initial investigation into a complaint, end quote, filed against him. Now, despite the substantiation of the evidence and despite the IA's investigation, Director Drummond did note that Officer Kilbane took responsibility and admission for his misleading. He did find that his conduct when questioned under oath was admitted to. As a result, Director Drummond found that misconduct more closely comported with a Group 2 level violation, specifically that the, quote, conduct that is contrary to the values of the division or that interferes with its mission, operations, or professional image, or that involves a demonstrable serious risk of officer or public safety, to the officer or public safety. As a result, based upon this finding, Director Drummond did amend the specification number 1 from a Group 3 level violation to a Group 2 level violation. Director Drummond then determined to impose a 6-day violation as a result of the amended specification and his conclusion thereto. Now turning to specification number 2. Specification number 2 surrounds a finding and conclusion made by the Medina County Court of Common Pleas Domestic Relations Division concerning a matter filed by a third-party petitioner against Officer Kilbane. The petitioner in the matter filed a temporary protection order and a civil protection order against Officer Kilbane. The underlying incidents that support that protection order include, but are not limited to, Officer Kilbane's placing tracking devices on the petitioner's vehicle on numerous occasions, including during the Medina incident, and entering her unoccupied vehicle during another incident. Now, the court in Medina County ultimately determined to deny the civil protection order in favor of Officer Kilbane. The court found that the evidence did not meet the legal threshold under Ohio law to impose a 5-year CPO, civil protection order. Specifically, the court found that the protection order was not necessary to prevent further domestic violence. Despite denying the civil protection order, the court did expressly opine that the basic elements, quote, the basic elements of menacing by stalking had been met, end quote, based upon the conduct of Officer Kilbane. Now, based upon the court's finding, IA did find that the preponderance of evidence supported the specification as previously noted. The specification being that Officer Kilbane engaged in the conduct of menacing by stalking, Ohio Revised Code 2903.211, in violation of Manual Rules 2.01. All 3 levels of IA review concurred with this finding and conclusion. Officer Kilbane received notice of this in connection with the notice associated with the other specification. Officer Kilbane did attend the pre-disciplinary hearing and was heard. Now, this charge was again charged as a Group 3 violation, which is the most egregious violation under the disciplinary matrix. Despite the 3 levels of review that the preponderance of the evidence supported this specification, Director Drummond did dismiss specification number 2 without explanation. The decision to impose or not impose the discipline relative to this specification and specification number 1 is what is currently under review by this commission. As a reminder, Charter 115.5 provides that the City of Cleveland Community Police Commission is the final city authority on whether the discipline of police officers imposed or not imposed by the executive head, here Director Drummond, is sufficient. This commission's decision is guided by the record evidence before it, the presentation today, any documentary or other testimonial evidence as a result of today, and the disciplinary matrix. I'm happy to answer any questions.
All right, thank you. Are there any commissioners who have questions for Executive Director Nordy? Do I have Commissioner Coleman? Anyone besides Commissioner Coleman? Commissioner?
Yeah, through the chair, interim executive director, my question is, through your review of the entire case package, were you able to glean anywhere the reasoning for specification 2 being dismissed? I saw the reasoning for 1, but I didn't see one for 2.
No, I was not. There was nothing on its face that could indicate why.
Okay, and through the chairs, you might not know the answer to this, but I am wondering if you know whether in practice the Manual of Rules 2.01, which is, for essentially violating a law, is that usually based on an actual criminal determination, or is it normal for IA to actually discern whether or not they believe a crime has been committed?
I would believe the latter, and that is because the violation of Manual of Rules 2.01 does not require as a prerequisite sort of a probable cause independent finding by a prosecutor.
Thank you.
Any other questions? All right, so next we will, excuse me, just for the formality, but for Respondent Officer Kilbane. Okay. All right. So I think next what we'll do is we will ask Public Safety Director Drummond to come to the commission as a witness for questions. Or his representative.
Am I being called by commission or?
The commission.
So at this point, are there any commissioners that would like to ask questions of Director Drummond?
Sure.
We got Laura Benito. Thank you. So just before we allow the public safety director to make a statement of his own, I have Commissioners Trua, Coleman, Kincaid, Morel Benito, Nelson, Van Leer, and Zayed. Anyone else want to go after himself? All right, thank you. Chief Director.
Hello, can anyone hear me okay?
Yes.
All right, I have no opening statements, just here to answer questions.
Okay. So we'll go with Commissioner Morel Benito.
And just to clarify, if we have multiple questions, we start with one and then we'll come back around later. Okay. Public Safety Director Drummond, thank you for being here.
Sure.
I was wondering if you could explain to the commission your reasoning for dropping the specification 2 in this case, to charge the group 3 violation related to Manual of Rules 2.01.
For which, for,
For specification 2 of the specification related to the medicine pack docking.
I mean, why I didn't drop it, I dismissed the case itself. And
Thank you. Why you dismissed it?
sure, it was just after reviewing the facts and consulting with the law department. So it's
Sorry, could you
important.
move the mic maybe up a little bit?
Sure.
Yeah, I think you should just be able to pull the stand up.
A second here. Okay, comes up.
No, tighten it, yeah. That should be good.
Yeah, I mean, I'm doing that.
Thank you.
All right, just a little better?
Yeah.
All right, okay. I dismiss specification number 2 after reviewing the facts and consulting with the law department and others as well. It's not just the law department. I determined that there were not sufficient evidence for a finding of a guilt based on specification number 2.
All right. Thank you. Commissioner Kincaid.
I actually had a very similar question, but I was going to refer to the first case, the first specification in the matter. If you can maybe shed some light for us on what prompted you to vacate the recommendation of internal affairs in that matter and reduce it to a group 2 violation from the proposed group 3 violation.
Thank you for the question. I considered all the facts, all the evidence and testimony presented during the pre-disciplinary process. I take all that in consideration, and then I arrived at the determination I made against, even with this particular specification, not just this specification at all. I consulted with the law department, assistant directors, and those in attendance at the pre-disciplinary hearing and through the process. And my decision is set forth, obviously, in the April 24th, 2024 disposition letter. And my reasons set forth in the letter, I believe to be issued consistent with the disciplinary matrix, which was mentioned several times by the executive director, to be fair and again, fair, appropriate, and consistent. And again, my decisions are made not in a vacuum, but with reviewing all the evidence presented, testimony, and then ultimately make that determination. And that was part of that process.
Thank you. Commissioner Nelson.
Good evening, Director.
Good evening, Judge.
Have you had a chance to determine if the discipline that you did impose was sufficient to correct and address the officer's behavior and conduct?
Thank you. I appreciate the question. Yes, I believe the 6-day suspension that Officer Cobain received was sufficient, necessary to correct the behavior that was displayed during that particular incident with the victim.
Thank you.
Yeah.
Thank you. Commissioner Van Leer.
Through the chair to the safety director. I may have questions about both, but I'll start. You were just talking about the specification number 1. As I read it, looking at the discipline matrix, it seemed to be clearly a false statement, untruthfulness, or dishonesty, which, according to the discipline matrix, is a group 3 violation. So you sort of said, you've given some answers, but I'd like to go a little bit deeper on what exactly made it less serious to not be a group 3, because the language there is clear, and the previous rulings by the division, had made it clear that it was a group 3. So I'd like to have a lot more clarification of your thinking about why somebody who lied to the Medina Police Department wasn't making a false statement or an untruthful statement or being dishonest.
Thank you, Mr. Van Leer, for the question. Again, I'm going to repeat. I'm going to probably repeat some of the things. I consider all the facts, the evidence, and testimony during that particular hearing. I know that during the testimony of Officer Kilbane, at least, I'm sorry, not the testimony, his interview with Internal Affairs, our Internal Affairs, he was forthright in his responses. He did not evade any responses for our Internal Affairs investigators. He was honest in his testimony, or his testimony to the, or statement, testimony, his evidence, his statement to the Internal Affairs investigators about his misleading the investigators from Medina. So it's forthright with them. And again, based on the facts, the evidence, the testimony presented at the hearing, I made that determination to lower the specification from a 3 to a 2 and impose a 6-day suspension.
Thank you. Commissioner Truro.
Hi, Director.
How are you doing, sir?
Good. You're the final arbitrator of the facts in a police investigation accumulated in a hearing in front of you. I would say the Internal Affairs would be like the officers investigating it.
Yes, sir.
And then you have a charging officer who acts like the prosecutor for the city. And you would be the final judge to determine everything.
That's a good way of analyzing it. That's correct. And during my my determination, again, it's not made in a vacuum. I do consult with the law department. The law department, we have an attorney from the law department that sits in on these hearings, so it's important to note that as well. I have assistant directors sit with me periodically through to the pre-disciplinary hearings and so forth. And we also have, as you stated, Jimmy, if you don't mind me calling you Jimmy, we do have a case preparation officer, which is considered sort of like a quasi prosecutor at the hearings and so forth. So we sit down, we talk, and I look at the disciplinary matrix and look at everything, and then ultimately come to a final determination. I make the final determination because I am the safety director, stops with me, and I make the final determination after consulting with all those individuals.
I think you've answered any other question I had at this point. Thank you,
Thank you.
Director.
Thank you. Next, we have Commissioner Coleman.
First of all, thank you so much for being here. This is actually very helpful for us. I do appreciate your time today. My question is, even outside of this case, I'm just wondering how it generally works. Is for this manual of rule 2.01, which is essentially an officer committing a crime, is it common that a crime will have been determined to have occurred even when there are no criminal charges? Like, normally, are there criminal charges when this rule is implemented, or is it no, you just will look at the facts and determine yourself whether a crime has been committed?
Thanks for the question. That's a good question. I want to make sure that I understood your question. You do not have to have a crime that's committed or charged, a crime that's charged by the prosecutor, whether it's the county prosecutor or the city prosecutor. Based on the rule, you can have been alleged to have committed a crime, but not necessarily have been charged criminally with the charge. If that makes sense.
And that I understand,
Okay.
but in practice, how does it normally work out? Is it just either or?
Yes, ma'am.
Okay.
Yes.
Thank you. Are there any other commissioners with questions?
I have one.
Okay, so we'll go, Maria Benito, you want that? So what I'll do is I'll take another roll call just so we know who would like to speak again. So I know we have Commissioner Benito, Maria Benito. We also have Commissioner Kincaid. We have Commissioner Coleman. Anyone else? Okay, so we'll do the second round.
Add my name to the co-chair, add my name to the list. Someone may ask my question. If they do, I'll withdraw.
Point of order, are we supposed to be addressing the co-chairs or through the co-chairs?
Yeah, so as a reminder, we will, everyone should speak through the chairs and not directly to Director Drummond.
For point of order, is that same thing for me to the chair, to them as well?
Yes, sir.
Okay.
So we'll begin again with Commissioner Maria Benito.
To the chair. So you stated, or to the chair, it was stated that in your review of classification 2, that you reviewed the body of evidence and you determined that there wasn't sufficient evidence to determine that the officer had committed the crime of menacing by stalking. And in reading the magistrate's decision, Magistrate Aaron Daisy, in the domestic violence protection order petition, where they reviewed a significant body of evidence and determined that they believed that there was sufficient evidence that menacing by stalking had occurred, and then that was also agreed with by Internal Affairs. I'm just wondering if you could speak to what evidence did you see that made you think that that was not sufficient evidence?
Thank you again for the question. Again, I said before, I'm sorry, through the chair. I'm going to repeat myself because, again, I reviewed all the facts. I know you mentioned that, and all the evidence, and consulted with the law department. Again, it's important to understand, I'll keep stressing it, that I do not make these decisions in a vacuum. It's important to understand that. I don't sit somewhere and just make the decision. I consult with the law department. I consult the assistant directors that sit in the hearing with me, and I consult the case preparation officer, And I also consult with the matrix, the disciplinary matrix that sits right in front of us. When we're looking over the evidence, want to make sure that we're consistent in meting out discipline if that's the case, if the officer, employee, or member is found in violation of the allegations or the specifications. And based on my consulting with the law department, looking at the facts, looking at the evidence and so forth, I made a determination there was insufficient evidence or not sufficient evidence on the grounds of finding, not sufficient evidence finding him guilty of specification number 2.
Thank you. Commissioner Kincaid.
Through the chair, are there any other factors, maybe personal factors to the officer, their time on the job or their like overall character, or if they've ever had discipline before, any of those things that also weigh into the decisions that are made in regard to their discipline? Or is it strictly a case by case, this situation, this matrix, this, or are there other considerations made?
It's made by the facts of the case, what's presented, the evidence that we can prove, or the IA or other member, whether supervisor is bringing the specifications against that member. Emotions are completely out of it. It's important to understand there are no emotions involved in it. If the person or the member is found guilty of violating specification, then there are many factors that are taken into consideration, to your point. Then we look at, again, based on aggravating, mitigating factors, those play into prior discipline. All those things are taken into consideration when I'm making my determination to impose whether or not to impose discipline.
Thanks, sir. Next, we have Commissioner Coleman.
Through the chair, my question is concerning mitigating and aggravating factors and how they play into the disciplinary matrix. And the simple question is, do mitigating and aggravating factors allow you to move up or down within the violations? So can you use mitigating and aggravating factors to move from a group 2 to a group 3, vice versa?
Through the chair to Commissioner Coleman. Again, great question. The mitigating and aggravating circumstances are based after. If I'm going to make a determination to push a specification up or down, or grouping, I do not take into consideration mitigation or aggravating until after I make that determination. So once I decide that a member is guilty of a specification, we look at the specification itself, determine if it's appropriate, and if we don't believe, and I say we, again, because the decision is not made in a vacuum, then that determination is to move that specification or grouping down or up, depending. Generally, we don't move it up, We move that specification down, and then at that particular point, then the aggravating or mitigating, prior discipline, lack of discipline, all that is taken into consideration before the actual discipline is meted out.
Thank you. Commissioner Nelson, do you still have Commissioner Van Day.
Okay. So I'm formulating a question in my head, and it might be more than one question, so I apologize that went through the co-chair. As we've worked on a revised corrective action general police order, the idea of discretion has come up a lot. And you said through the chair of the director, you mentioned consistency. So I wonder if you could address sort of if there's any tension between that idea of discretion in making these decisions and consistency in being consistent across multiple cases. And I think about that because there have been, before your decision was made, particularly on specification 2 to dismiss, there were multiple levels of processes, right? And I would assume all of them were very thoughtful and thorough based on the documents. They certainly were. So yours, the director's, was not the only one that was that thoughtful and thorough. So I'm wondering how discretion and consistency play out. And I guess the second part of that long-winded question is, in your experience, both as a safety director, as a police chief, and even just as an observer before you were in those roles, were there similar cases that you or others have decided, things that you drew on or maybe just were aware of, like here's a case that you, in your memory, was specific that led you down a certain path or didn't, but just felt was similar in terms of that consistency, like thinking in terms of consistency. So the two questions were, I hope they were clear.
Through the chair, I think I understand your question. I believe I do. Consistency is extremely important to me. And I would think anyone that's sitting in my position to be consistent. I can't say years ago, and I mean years ago, that consistency was there. But for me, whether I was a commander, deputy chief, and now safety director, to be consistent, no matter who the individual is that's in front of me, is extremely important to me. In making this determination in this particular case, one of the things, and you can ask anyone that sits in any of my hearings or even afterwards, what I stress all the time: consistency. We have to be consistent and fair and appropriate across the board. We take out the disciplinary matrix, and even as we're going through that process and talking through it and so forth, if it's a group 3, we're thinking about going down to a group 2, the question asks, I want to make sure that we're consistent when we apply the discipline. That's extremely important to me. So I do that no matter, I do that consistently. I'm consistent in what I do and I apply the discipline if I'm going to impose discipline, consistent across the board, consistent with past practice and what we've done, consistent with the disciplinary matrix, and to make sure that I'm fair to all the members that may unfortunately come up in front of a disciplinary process.
You follow up?
Yeah, just to follow up through the chair is, can you speak to similar cases in the past, especially since 2019 when this corrective action guidance, the GPO, the disciplinary GPO was revised and operationalized? Are there specific examples or types of cases that you feel like show that consistency that you could draw on?
Through the chair, I don't have any in particular. I didn't know that I would have to potentially answer questions relative to that. But for me, again, I'm consistent, and I pride myself on being consistent with the disciplinary matrix and just my decisions relative to imposing discipline.
Thank you. Commissioner Nelson, do you still have a question you wanted to ask?
To the chair, to the director, I have no additional questions on this matter. Thank you.
So we'll go back to Commissioner Morel Benito.
To the chair, how many rounds of questioning?
This will be.
I don't think that the rules say, the rules say during discussion that you can't speak more than twice, but I don't think it says during question. But this is my last question. I can answer that.
Okay, I will let you go a third time.
Thank you. My last question is under group 3 violations where it says false report, false statement, untruthfulness, or dishonesty. To the chair, I'm wondering if there is any regulation around who that applies to. Is it only to members of the division? Is it to potentially to other police departments, other public officials? In what settings is a group that false report, false statement, untruthfulness, or dishonesty considered?
Through the chair to Commissioner. Again, I appreciate the question. It's a good question. I can tell you that when our member was interviewed by Internal Affairs, the CDP, Internal Affairs, he was forthcoming. He admitted to misleading the Medina Police Department, took responsibility for his actions, and then based on, again, the facts, the evidence, and the testimony, I made my determination.
Can I clarify? I'm asking about the rule in general, who it applies to.
for just to clarify, I think the question, Director, is that statement of the segment of untruthfulness, does that apply? In what settings does that apply? Is that applied generally across the board? Is it applied in CP official capacity? Like, does it hold weight when the officer is not in official capacity? I think that's kind of what.
Yeah, I think the question is, in which settings is an officer expected to be honest?
Through the chair, Commissioner, again, I appreciate the question. We expect our officers to be honest. As everyone's aware here, your behavior is when you're on duty or off duty. But I can tell you that, again, when the officer was brought into IA, Internal Affairs, forthright to the investigators, and took responsibility for misleading the Medina Police Department.
I just want to, I appreciate you answering these questions, but I want to ask just a few myself. So to follow with Commissioner Benito's question, so would the expectation be that Officer Kilbane should have been honest and truthful with Medina Police? Would that, from your standard, would that have been the expectation?
Through the chair, yes.
Thank you, sir. And then lastly, I wanted to follow up on the conversation that was had about mitigating aggravating factors that I think came up earlier. I just wanted to know, is this a scenario where you use any mitigating or aggravating factors once you make the determinations for the group violations?
Once I make the determination, then I consider mitigating and aggravating circumstances.
Yes, thank you. But I'm asking, in this particular case, did that occur?
Yes, sir.
Okay.
Sorry, yes, sir.
Thank
Through
you.
the chair, yes.
I appreciate it. Thank you. I think that's all we have. We really appreciate your time, and thank you for coming.
Thanks.
Thank you.
To the chair,
Yes, sir.
is it appropriate now to move for executive session, or is there another matter that needs to be addressed?
We're very close. So we need to give Officer Kilbane an opportunity for a closing statement. And I don't know if anyone's come in, but do we have any representation for Officer Kilbane for a statement? I just want to make sure that if someone came in that. Okay. All right. So next we will move on to closing statements. Each party may present a closing statement, summarize their arguments, and the statement may not exceed 10 minutes. Executive Director, would you like to make a closing statement?
Based upon the objectivity and neutrality of the ED's position as it's contained in the rules governing this proceeding, I will refrain from making any statement. Thank you.
Thank you. So since this case is in consideration of a personnel issue, the commission will move into executive session for purposes of deliberation and to consider the discipline of a public employee. We have a motion. Do we have a motion to enter executive session?
So moved, Mr. Chairman.
Thank you, sir. Do we have a
I'll
second? We have a second.
Second.
And so we'll call for the vote to move into executive session. Commissioner Chur?
Aye.
Commissioner Coleman?
Aye.
Commissioner Kincaid?
Aye.
Commissioner Mason?
Aye.
Commissioner Miller?
Aye.
Commissioner Maria Benito?
Aye.
Commissioner Nelson?
Aye.
Commissioner Unison?
Aye.
Commissioner Van Leer?
Aye.
Commissioner Zayed?
Aye.
And I vote yes as well. This commission will now move into executive session.
Do you want to explain to the group how we're doing, do you want to explain to the people in the audience that they can stay or whether we're leaving?
So the commission will move on to a different location, so therefore all members of the public that are here can just stay in the space here.
Alex, are you staying here?
You guys can call us on me if needed, but I stand more guide you guys.
Alex, you can roll call.
Chief, can you grab my cell phone?
Might
be in that bag.
Oh, dude.
Yeah.
I want to be here.
Yeah. And this is the biggest one we get to.